In such view of the matter, the trial court has rightly extended the benefit of doubt to the accused, Musamma Taj Bibi. Hence, the second point pressed into service is of no avail to appellant. Now, coming to the next contention of learned counsel, that is, delay in the recording of the confession. Apparently, though the statement appears to have been recorded with delay of almost 6 days, but the chain of the circumstances that led to pointation of place of occurrence, recovery of blood-stained X on 7th March 2009, and thereafter within 4 days, the recording of the confessional statement does not appear to have been recorded with delay. The perusal of statements reflects that all the necessary questions were put to the appellant. We are conscious that one necessary question is lacking in the questionnaire. However, while examining the magistrate, the same was clarified to have been put, and the answer to cross-examination number 4 is quite relevant. In view of peculiar circumstances of this case, we are of the opinion that there is no such delay which may reduce the veracity and admissibility of the statement recorded under Section 164 CRPC. There is no cavil with the legal proposition that while evaluating the confessional statement, main object of law is to ensure the voluntariness and truthfulness of the statement. If a statement is found to have been made voluntarily without duress, coercion, and inducement, and simultaneously rings true, there is no impediment to accept the same, irrespective of delay, if any, if recorded within the period of legal physical remand with police. Reliance is placed on judgment titled Majid versus the State, reported in 2010 SCMR, page 55. Relevant, wherein it has been held as under. No doubt there was delay of 12 days in recording the question, but in recording the confession, but this by itself is not sufficient to discard the same. This court in the case of Nabi Baksh versus the State 1999 SCMR 1972 held that delay in recording the confessional statements by itself is not sufficient to affect its validity. However, no hard and fast rule can certainly be laid down about the period within which the confessional statement of the accused ought to be recorded during investigation. Reference is also invited to Muhammad Yaqub versus State 92 SCMR 1983. Reference can also be made to the judgment titled as Muhammad Ismail and another versus the State, reported in 95 SCMR 1615. Then comes the confession of appellant Muhammad Ismail. Delay for recording confession per se is no ground to discard it unless it is proved or emerges from the circumstances that it was obtained by coercion, threat, pressure, etc. Indeed, the learned magistrate, after observing formalities, recorded his confession and certified that it was true and voluntary. Full stop.